Köszönöm szépen a kedves felvezető szavakat.
Thank you very much for the kind introduction, and I thank you for the opportunity to attend your conference and to speak to you. I am the odd one out in a way because we are celebrating the 10th anniversary. We are celebrating the 10th anniversary of the Criminal Code, and I feel that I am the odd one out in one way because so I have a very specific topic, but I believe that some of the previous speakers made presentations to which I can join my own presentation. As the introduction mentioned, I will talk about coercive measures in the criminal procedure. This is the topic of my presentation, and it's not only because it is very close to my heart, but it is also because a book was mentioned by Robert Bacco, which is now under preparation, and I am writing the chapter on this topic of that book. So the coercive measures that are applicable in the criminal procedure have been in the center of domestic and international attention for several reasons. On the one hand, there are many international organizations that endeavor to make sure that victims are not subjected to disproportionate measures, and they are trying to formulate certain requirements that the legislator should take into account. And the control organizations working in conjunction with international organizations keep a watch over the enforcement of these measures. But in addition to these international organizations, there are many NGOs and scientific associations that are analyzing the appropriateness of this chapter of the Criminal Code as well as its implementation. We could also argue that the analysis or investigation of coercive measures is always a fashionable thing to do because something is always up in this area. There are cases that are in the focus of attention in any country and also in the international arena. And this is especially true for coercive measures involving imprisonment and arrestation and police custody, according to the Hungarian terminology. And according to Hungarian terminology is to be stressed in this context because there may be differences with other countries, and this situation can be resolved by an in-depth analysis of the cases. In Chapter 8, the Hungarian Criminal Code regulates coercive measures affecting the personal freedom but also property. This solution, however, cannot be called general at all. There are some countries in which seizure, which is a coercive measure affecting property in Hungary, is listed as a collection of evidence and not listed as a coercive measure at all. And coercive measures affecting personal freedom, however, is generally identical in the various EU countries. So custody, arrest, and other forms of coercive measures are also available, and these are generally handled as alternatives to arrest. So after this introduction, I think it is comprehensible that there are several reasons that justified that we write an entire chapter in this book about this issue, and that we mainly focus on measures affecting personal freedom, and that we are only mentioning the coercive measures affecting property. In the center of attention, we have the Central and Eastern European countries, and especially legislation legislation and practice in the area, and it would have been an impossible exercise to attempt to give a full account of the situation in these countries. The investigation covers several countries, and therefore the chances were meager that the information be available in a language that is spoken by the researcher. So in this context, I feel compelled to say thanks to a large number of foreign colleagues whom I do not know in person, who have supported our work by identifying English language text sources for their country's legislation and pointing to valuable research studies dealing with these legal institutions. As legislation has a tendency to change frequently, as Mr. Bako also mentioned, it is quite often the case that I may be talking about something today unawares of the fact that it is no longer in effect. And it does not only apply to Hungary, it is also the case in many other countries. So we had to be very cautious when we were reading studies and books about the situation in various countries. I must also mention that with regard to some countries, we had access to very limited information only, and this was a serious impediment in our efforts to write a comparative study. So the examples that we have been able to identify were eventually only used as illustration in discussing some matters. Our intention to write the book, with writing the book, is also to make it a useful source of information for the education of law students. So that was also on our mind. So why do we have to deal or to analyze these problems in the first place? For experts involved in criminal procedures, this is not a real question. Over 3 million people in the world are awaiting their trials in law enforcement institutions, in prisons. In many European countries, 1/3 of the detainees belong to this group, and those in pre-trial detention in the European Union make up roughly 22% of the prison population. And please remember that the presumption of innocence is in place with regard to them, because a final court decision has not yet concluded that they committed a crime. They are just awaiting a sentence. Arrest has several negative consequences. It puts not only the charged into a detrimental situation, but also their entire family. And this situation also restricts their rights. I often quote from the words of István Szokolai, who describes the disadvantages of detention, and I am quoting, "His reputation is totally destroyed. The imprisonment damages his health. His revenues, his economic activity comes to a halt, and he is put at a disadvantage that may never be eliminated. The peace of the family is undermined, and their life is made impossible." You can conclude from the wording that it is quite an ancient text. The author was born in 1853. And I quoted from his work because I wanted to illustrate that in this respect, unfortunately, the world has not progressed very much. In spite of the geographical and the chronological distance, I believe we can conclude that the situation has not changed much until the present day. And this will not be a verbatim quote. The arrested person is isolated from his or her family and friends. There is the danger that he will lose his job
job and his home, and presumably his reputation will also be destroyed. And these are the words of the conclusion of a study that was conducted only a couple of years ago. So 160 more years have not made a big difference in this respect. Let me also say that several NGOs are also focusing on the national enforcement of the rights of the charged. And the United Nations and the Council of Europe document all identify very clear rules and requirements, and they make it clear that arrestation should only be a last resort if that is absolutely necessary and the procedural objectives cannot be achieved by any other way, by other measures representing less restriction. The states must ensure that a proper replacement exists for arrestation, that realistic alternatives are available. However, in spite of these requirements of the United Nations and the Council of Europe, several studies have concluded that arrestation is not a last resort in many countries, and alternatives are only used to a very restricted degree. So you can tick the box for the existence of alternatives, but their application in practice happens to such a meager degree that in effect there is almost no chance for the procedural authorities to order anything else than arrestation. And also several studies have concluded that resolutions for pre-trial detention are not justified properly, and I am sure that the defense lawyers will confirm my conclusion in this respect, and that in every case regular review is not taking place, and this brings about a situation when detention can be prolonged for a very long time. I do wish to stress that my statements are not restricted to the Hungarian specificities, and that my conclusions are based on a broader international study. And concerning a few thoughts related to the activities of the Council of Europe. So requirements for pre-trial detention have been recorded for several decades. The Council of Ministers first passed its resolution in 1965, recording the criteria for detention. These expectations and requirements are related to ordering arrestation and then implementing it. And then later in 1985, it adopted a recommendation, and in 2006, these instruments were replaced by Recommendation 13 issued by the Council of Ministers. And this latter, or the last one that I mentioned, is quite long, and the time does not allow me to give you a detailed account of it. But there are two fundamental requirements that I wish to stress. Number one being that a substantiated suspicion should exist that the suspect committed the crime, which is a fundamental requirement in the case of ordering any coercive measure affecting personal freedom. And the second, that pre-trial detention should only take place against persons who are suspected for a crime whose legal consequence is imprisonment. So well-substantiated suspicion is one basic requirement for pre-trial detention. It is a general requirement. And in 14 cases, the threshold is higher, and a pre-trial detention can only be ordered if the crime carries a punishment of 1 year in prison or longer. Such proposals are surfacing in Hungary regularly whenever any codification process is ongoing, but the legislator has not yet accepted this. And there are also special reasons that must be in the case if detention is to be ordered. and there are 4 potential reasons, and I would like to stress 3: the danger of the charged escaping, the danger of the charged committing another serious crime, number 3 being the intervention in the process of the dissemination of justice, and the protection of public order or the potential for disturbing public order. So the crime can disturb the public order is the fourth such reason, and this fourth reason is regulated in as many as 12 member states of the European Union, but this is what NGOs have criticized, as well as several other studies have criticized it, because it represents a rather subjective and controversial requirement. So what is the case in the European Union in general? I think it is a very valid question to ask that when every EU member state is a signatory to the EU's Convention on Human Rights, how is it possible that in the practice of the European Court of Justice, there are certain requirements that every country still has not been able to meet? At the moment, we do not have shared EU norms for the conditions of pre-trial detention and detention in general. The Council of Ministers has already issued a schedule for making amends. In this respect, it is a recommendation that was adopted in 2009, and it focuses on issues related to pre-trial detention too. So there is a schedule, and it includes a measure F, as it is called, and as part of it, a green book on pre-trial detention has been published. And it includes rather modest expectations, namely that such a green book has to be drawn up. We know now that there are other requirements, the right to interpreting, the presumption of innocence, and etc. In relation to all these requirements, directives have been adopted that include the minimum requirements to be met by the member states. But in terms of arrest, the measure itself is nothing more than the preparation of the Green Book, which is itself a matter for debate. And in the explanation part of this measure, it is written, and I want to stress that it was written in 2009 by the Council, so it was written there that in each member state the time period is very different, that any person can spend in pre-trial detention. An excessively long pre-trial detention is detrimental to the individual and may have an unfavorable impact on the cooperation in justice among the member states, and it does not represent the values professed by the European Union. So the Council asked the Commission to prepare the Green Book, and this had taken place, and it was subjected to general debate in 2011. But ever since then, no EU norm has been created, including norms to which everybody is committed. And then in 2016, the Commission prepared a comparative study about pre-trial detention in the EU member states. Unfortunately, I have not been able to locate this study, but I am not giving up. I continue my search. And in the study, and this I realized from a summary material of the Commission. So I realized this, namely that there are differences concerning the regulations of pre-trial detention, and they concluded that this is the source of countless problems. At the beginning of this year, however, something happened. The European Commission published an initiative called the Recommendation for Pre-Trial Detention. And the purpose of this is to identify certain aspects in the practice here regarding which there is a need for improving convergence among member states, because that better convergence would facilitate a better cooperation in justice matters. And the problems identified are almost exactly the same that had already been identified by various NGOs, as well as the practice of the European Court of Human Rights. These problems, and there are three groups of these problems, are the following. Decision-making before court procedures is a routine in many countries, and it does not include a resolution based on reasons. Number two, some countries do not provide alternatives before the procedure, for example, ban on traveling or remote or distance hearing, etc. And even if they exist as alternatives, they are not very often applied before indictment. The judges and the prosecutors are not familiar with the international norms that are applicable in this area. Those present here today, of course, represent an exception. And the existing practice is detrimental to the mutual confidence among the European member states based on the European arrest warrant. For example, the transition of the detainee is difficult from one country to another because the circumstances in the target country may be so negative that the sending country cannot accept them. And in order to approximate the situation to the desired international norms, as part of the initiative that I have mentioned, the European Commission is currently planning that by Q4 of 2022, they will adopt a recommendation. But we are already in the fourth quarter of 2022, but I have not yet encountered even a draft for this recommendation. And the specific operational policy objective of the recommendation is said to be the following. The material conditions for detention and pre-trial detention should be based on identified norms that are in harmony with the European Convention on Human Rights, as well as other international treaties on human rights, and the alternatives to pre-trial detention should be applied by the national courts to a higher degree. That is the second objective, in harmony with the principle that detention should be a last resort. And let me here add that there is a problem. Namely that if we open the Hungarian and English translations or texts of this initiative, we will find that the Hungarian text is referring to custodial arrest instead of detention. So we are talking about arrestation and detention here, and not custodial arrest. So there is a lot of terminology issues here. Detention, custody, custodial arrest, and the way it is being translated into the Hungarian materials has been a source of serious concern. And of course, the implementation of the recommendation will be the responsibility of the national governments, and in 24 months they will have to report back to the Commission as to the measures that they have adopted and to how much their practice has been moved closer to these expectations. And the Commission will have passed an assessment of the situation in 36 months from the issuance of the recommendation. So we have still several years to wait for a result. However, I must also mention the case of the European Supervision Order. The declared objective of this order was not to harmonize the procedural regulations in the member states, yet, however, the supervision measures that are mentioned here as examples, namely that these measures are available instead of using detention. These rules are funnily incorporated not only in the Hungarian legislation but in many other national legislation frameworks in Central and Eastern Europe. In terms of supervision measures, I do wish to tell you that the supervision order splits these measures into two categories. One is the category for measures that are mandatory, and the other is the measures that are optional. We are pressed for time. I will not give you a list of all of them, but let me stress that the Hungarian probation supervision or other coercive measures is the place where these are inserted. And EU directives of other topics also include measures that had indirectly an impact on the rules of detention and arrestation. Concerning the actual implementation of the procedure and the enforcement of the rights of the charged. International organizations, and most recently, the requirements imposed by the European Union too have resulted in an approximation of the legislation of Central European countries as well. So we have a more now a system that is more integrated. It is clear that it is the courts of justice that have a mandate to issue orders in this respect, and we have seen an approximation also in the duration of the detention among the various Central and Eastern European countries. Now, I have come to the point when I wish to illustrate my thesis with a few case examples from the countries that I was talking about, by which I hoped to prove that such an approximation had actually taken place. But unfortunately, in the lack of time, I have to skip this part. And without specific examples, this presentation is not as illustrative as I had intended it to be, but I hope that you still feel that there are many measures that impacted the legislation of Central and Eastern European countries, and we can conclude that there are some strong similarities by today, and in spite of some differences, there are a couple of rather interesting solutions that I could not present to you, unfortunately, in the framework of this presentation. But it is to be stressed that we need consistent and strict rules when it comes to coercive measures, rules that do not lend themselves to a very versatile application. We need more harmonization too in certain aspects of coercive measures among even the European member states in general, primarily in order to strengthen the confidence that we have in the legal system of other EU member states. Thank you very much for your attention.